Okay.
1 minute. I will say.
स्क्रीन शेयर इधर से हो रहा है, आवाज वहां से आ रही है, लीक लाइक दैट।
वो नहीं, यहाँ से उसको तो बंद ही कर दो।
ये बंद कर दूं?
हाँ, इसको शेयर कर, सेव करना है। ओके, ओके, राइट, ठीक है, थैंक्स। ओके, sorry, I think we have almost lost 15 more than 15 minutes, huh? But let's start the session at the earliest. I have prepared one PPT on today's topic, which is due diligence before finalizing a resolution plan. Huh? So let me share my PPT with you, and then I start the session. Hope you can see it on my screen.
Yes, sir.
Yes, sir.
Yes. Objective of the code. So as you are aware that the objective of the code, which is contained in our preamble. So we start with that: an act to consolidate and amend the laws relating to reorganization and insolvency resolution of the corporate persons, partnership firms, and individuals. Okay, so amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interest of all stakeholders, including alteration in the order of priority of payment of government dues, and to establish an IBBI, and for matters connected therewith or incidental thereto. So, as you are aware that prior to notification of this law, we were having a number of other laws where the provisions relating to insolvency, dealing with the insolvency, winding up, reorganization, etc. So provisions were contained in a number of enactments, and through this law, the objective was that all these laws, all these provisions, which are spread over a number of enactments, they are consolidated in one law. And this law, Insolvency and Bankruptcy Code, you are aware that earlier we were having two insolvency laws, so which were now after notification of all the provisions, so those will be repealed. We were having Sikh Industrial Companies Act also, which dealt with the insolvency resolution of Sikh industrial companies, so only industrial companies. So that was the insolvency resolution earlier. Otherwise, insolvency resolution, so you know that under present law, we are having two types of processes. One is insolvency resolution, and second process is liquidation with respect to companies. Similarly, for individuals also, we are having insolvency resolution process, and then we are having bankruptcy process. Bankruptcy process and liquidation process, they are similar. They are similar in the sense that in both the processes, we have to sell the assets of the debtor, realize the money, and that money is distributed amongst the stakeholder as per the priority which is laid down under law. Okay, prior to that, we have placed the insolvency resolution process, which was not there earlier. Insolvency resolution process was not there earlier. Earlier, the law was that if there is a default, then next step is that company should be, you are aware that under the Companies Act 1956 and 2013 also, provisions were there for winding up of companies. So if inability to pay was there, if there is a default, then in that case, the companies were required to be wound up only. No provisions were there under Companies Act for the insolvency resolution of the companies. And similarly, for individuals also, the provisions were for bankruptcy. There were no provisions for insolvency resolution. So insolvency resolution is an attempt to see that if there can be a resolution, then an attempt is made to see that a resolution plan is formulated and approved. And if that does not take place within a time-bound manner, so the word in a time-bound manner, it is very important. Why this process is given 180 days time period or 270 days time period is that during this period, we are denying the creditors the right to make recovery. So we are telling them that you wait. During this period, moratorium will be there. So we are asking them not to continue with their recovery proceedings. So that is the reason that this time period should not be unlimited. It should be very brief. So 180 days time period has been prescribed for that purpose. So till now, before this law, the consequence of insolvency is what? Insolvency is when you are not able to pay your dues. So that is insolvency. And so consequence of insolvency was the winding up. That if a company is not able to pay its debts, then it should be wound up. Why it should be wound up? The reason for the same is that if a company is defaulting to its creditors, then it should not be allowed to contract further debt. It should not allow to raise money from the market. It should not purchase material on credit from the creditors. It should not engage employees whom the company will not be able to pay their salaries. Okay, so this type of company, if it is allowed to continue, then it will be committing a kind of fraud on the creditors. Because when you can't pay, then why should you raise money? Why should you be allowed to take credit from the market? So once you are an insolvent entity, so then immediately after that, this process should start so that market knows that this company is under insolvency and they don't extend any further credit, or if they extend any further credit, they do that at their own risk. Okay, so the consequence of insolvency used to be winding up or liquidation. Okay, however, under this law, considering the importance of resolution, these provisions have been placed before the winding up or liquidation process. Similarly, before bankruptcy also, there is an attempt that the stakeholders, they discuss amongst themselves and formulate a repayment plan, which is similar to a resolution plan. So this attempt, considering that it is very, very important that the businesses, they should continue. We want that businesses, if a company which is doing some business, if it is possible to save that business, then that business should be saved. And reason for the same is that the going concern value is more than the liquidation value. Not in all the cases. There can be non-viable businesses where going concern value may be less than the liquidation value. So in those cases, the company should be liquidated. But normally, if you are running a business, then going concern value should be higher than the liquidation value. And in that case, a resolution plan should be approved. And that resolution plan, why we want that resolution plan, why we want the business to continue, the reason for the same is that the company is giving employment to a number of employees, workers. It is producing goods and services which are consumed by the society. It is serving interest to the bankers. It is repaying their principal amount. then it is contributing to the state and center exchequer in the form of different taxes, income tax, GST, and others. So continuation of business in the interest of the economy, it is in the interest of the society. So that is the reason that these provisions have been placed before these before the provisions relating to winding up and bankruptcy. Okay, so insolvency resolution of corporate persons, you can see here that insolvency resolution words have been used here, but the liquidation, the word liquidation is not there. Okay, so that shows the importance of insolvency resolution. So insolvency resolution as per this preamble, as per this objective is important, but at the same time, liquidation is also important. Liquidation is not a bad word. If a business is non-viable, then the company should be liquidated. But if business is viable, then insolvency resolution should be there. Okay, so why liquidation is also important? Liquidation is important if a business is non-viable. If a business is likely to incur losses only, then in that case, the whatever resources are locked in that business, they should be pulled out. Okay, so what are the resources which are locked up in a business? So these resources are like laborers are there, workers, laborers, employees are there. So they should be utilized in some other viable businesses. Then capital is there, bankers' capital is there, suppliers' capital is there. So that capital is pulled out by selling the assets. So that capital which is free, it can be utilized for the purpose of other businesses. Okay, so these then land, building, plant and machinery. So land and building can be utilized for doing some other setting up of some other business or industry. Okay, plant and machinery, if it is usable, it can be used for some other purpose in some other industry. Other company having the same line of manufacturing and all. Okay, so for these reasons, liquidation is also important, but more important is insolvency resolution of viable companies because it is in the interest of the economy. Let's move forward. The definition of resolution plan. Section 526 of IBC, it defines resolution plan. And its meaning is a plan proposed by the resolution applicant. Okay, so a plan which is given by a resolution applicant, that is a resolution plan. And this plan has to be for the insolvency resolution of corporate debtor. Then, as a going concern in accordance with part 2. So, as a going concern is important. If your plan is that you will be selling, you will be disposing of the assets and will pay to the creditors as per section 53. So that is not a resolution plan actually. Your plan has to be based on continuation of business. Okay, business need not be absolutely same. It can be different. There can be different products which newer products may be there, which the RA says that he will be producing. He will be producing after approval of resolution plan. He may add some other products also. He may modify the product mix. Okay, he can add additional machinery. Okay, so all those things he can propose in the resolution plan, but the plan should be for continuation of business of the CD, and it may even be for continuation of even trading activities. So that can be, so continuation of business has to be there, and that plan only will be treated as a resolution plan. But in most of the cases, we are seeing that the plans normally they provide that they will be mostly people are interested in the real estate which is there in a company, and they are not interested in continuation of the business. So actually, as per the definition, if we see, so that is not a resolution plan falling within the definition of section 526. Then For the removal of doubts, it is hereby clarified that a resolution plan may include provisions for the restructuring of the CD, including by way of merger, amalgamation, and demerger. So this clarification or this explanation is that plan can be based on merger, amalgamation, and demerger also. Regulation 37 also provides these measures that yes, a resolution plan can be based on merger, amalgamation, and demerger. Okay. Then what is the definition of a resolution applicant? So a resolution applicant is a person who submits a resolution plan to the resolution professional. Okay. So whenever we invite expression of interest, a number of people, they show interest, we call them prospective resolution applicants. And then finally, these PRAs, they submit their resolution plans. And then finally, a resolution plan is approved. So all these applicants are prospective resolution applicant, or we may call them resolution applicants. And the successful one is called successful resolution applicant. Okay. A further definition of a resolution plan is a rehabilitation plan for a corporate debtor that is going into insolvency. Actually, rehabilitation plan and resolution plan are different. Rehabilitation plan is where lots of reliefs and concessions are granted. Earlier, you are aware that under Sikh Industrial Companies Act, the term which was used was rehabilitation plan. And under rehabilitation plan, under IBC, the parties used to provide various reliefs and concessions. Different state governments, they were having their relief packages for rehabilitation of Sikh industrial companies. Okay, but here the term which is used is a resolution plan, not a rehabilitation plan. So here you will see that in a resolution plan, though most of us, we provide a number of reliefs and concessions to be provided by different statutory authorities, government, central government, state government. A number of reliefs and concessions are provided in a resolution plan. However, the Honorable Adjudicating Authority is not having power under IBC to grant these reliefs and concessions. Okay, so even though we write these reliefs and concessions, these reliefs and concessions can't be granted by the approval of a resolution plan. So what can be then provided in a resolution plan? So most important thing is that resolution plan, under a resolution plan, all your past liabilities will be dealt with as per the resolution plan. If a resolution plan says that secured financial creditor will be getting some amount, unsecured financial and operational creditor will be getting some amount, statutory creditor, workers, and all that. So their treatment is provided in a resolution plan as to what will they get after approval of a resolution plan. Okay, so other than that, everything is to be written off. So all other debt other than what is provided in a resolution plan extinguishes. Okay, that is the biggest relief, though it is not something which is provided by someone. It is not something which is a sacrifice on the part of that creditor. It is something which that creditor is entitled as per the law. If a company becomes insolvent and suppose the value of asset or the value which is being offered by a resolution applicant is less than the liabilities, then in that case, the creditors, they are entitled to that money as per the provisions of Section 53. So if the company is not able to pay the statutory creditor, operational creditor, so that is it is as per law. They are not entitled to anything. Entire money is going to the secured financial creditor, and before that towards CRP cost. So that is as per law. So OCs, they are not actually making any sacrifice or any real sacrifice. Sacrifice is what you are offering, which you are entitled, but still you are making some sacrifice. That is a sacrifice. But here you are not entitled under law to anything. So there is no real sacrifice on your part. Your entitlement is that you will not get anything there. So under a resolution plan, important thing is that all the liabilities, past liabilities get waived off. All litigation, whatever litigations are going on, if a liability which is crystallized, if that is waived, then the other liabilities which are under litigation, that can't survive. They also get waived. But at the same time, as you are aware that in the case of litigations, wherever any litigation is there, the party which is having a right under that litigation, they have to file a claim before the RP, and RP has to, after studying the documents, he has to admit the claim, and that claim admission, as per that admission of the claim, a treatment has to be given in the resolution plan. So that particular creditor will be getting the treatment as per the treatment as per the resolution plan. And in the resolution plan, you have to deal with different classes in a similar manner. You can't say that all suppliers, they will be getting X percentage, but a particular creditor will be getting Y percentage. So all creditors in a class, all creditor in a particular class, they have to be dealt with in a similar manner. Okay. And so this is about a resolution plan and rehabilitation plan. As I said that if certain reliefs and concessions are sought in a resolution plan, then as RP, we have to ask the resolution applicant to write in the plan that two things. One, that the plan is not conditional upon grant of these reliefs and concessions, or even if these reliefs and concessions are not granted, he will still be implementing the plan. Okay. So then, or otherwise, we can ask them that in place of writing in the resolution plan that these different authorities will be granting them these reliefs and concession, we should ask them to write that these authorities will consider granting these reliefs and concession. So consideration can be there, but those authorities are not bound unless some relief or concession is as per the policy of that particular statutory authority. For example, our income tax department has made certain changes to IT Act. The government has made certain changes to Income Tax Act. One such change is under Section 79. That 79, under Section 79, carry forward of losses will be allowed, provided it is as per a resolution plan which is approved by NCLT under the provisions of IBC. And second, a opportunity of being heard is given to the concerned officer of Income Tax Department. Okay, so because that relief is already provided under law, so that the department can't say that I will not provide this relief to the this one. So in that case, our resolution plan can say that Section 79 relief will be provided as per the provisions of Section 79 relief will be provided as per the provisions of Section 79. Similarly, 115 JB is also there. So 115 JB also certain changes have been made. Okay, so that also relief can be made available provided it is as per the policy. So our scheme can provide that as per the policy or as per the provisions of section such and such, the relief will be provided to this party, to this resolution applicant. Okay, but if something is not there in the policy, then plan should not say that relief or concession will be provided. Rather, it should say that authorities will consider granting that relief. That means discretion will still be there with the statutory authority, whether it is Income Tax Department, GST department, or any other department. Okay. So let's come back to this definition. A resolution plan is a rehabilitation plan for a corporate debtor that is going into insolvency. It is a report based on the information memorandum provided by the RP that focuses on legal, financial management and technical methods to help the city get back on its feet. Okay, so legal provisions are there, financials are there, management and technical methods. So all these things are required to be provided in a resolution plan. Okay, so legal provisions are when we write that all other liabilities will be waived off, only those liabilities which are provided in the plan, to the extent they are provided in the plan, will be paid. So that is a legal provision under the resolution plan. Financial, as to how much money will be brought in by the promoter, and how much money, new promoter or resolution applicant, and how much money will be distributed to different stakeholders. So that is financial provisions of this. Management, as to how management of the company will be run after approval of a resolution plan. Technical methods to help the city, like if any technological changes have been there, or how you will be making the company viable. Okay, because if a company is engaged in some particular manufacturing activities, okay, so what changes will be made by the RA, because the operations may be lying closed for some period of time, the technology may have been outdated. So what steps are required to be taken by the RA to see that the operations become viable? Okay, technologically or technically, the machines can now manufacture in a viable manner. It must be approved by the committee of creditor and meet the IBC's required conditions before being approved by the adjudicating authority. So this is another definition of or description of a resolution plan. Approval. So we are aware the responsibility of approving a resolution plan rests with the COC, which will approve it with not less than 66% voting in favor of it. Another important thing I want to share with you, the insolvency resolution process, as you know, that entire powers, decision-making powers or commercial decision-making powers are with the COC. Okay, and under liquidation, you will observe that the powers are not there with the COC, or we constitute stakeholders consultation committee, SCC, under liquidation. But SCC is having only recommendatory power, but COC is having decision-making power. Why it is so? What is the reason that in one process we are giving all the powers with the COC, and in another process they are given only the recommendatory power? So answer to that is, as I explained to you earlier, that the outcome normally, or under earlier law, the outcome of insolvency was winding up or liquidation. Okay, and that was the process under which the court was running that process of liquidation, of selling the assets and distribution of the sale proceeds amongst the creditor through the official liquidator. So official liquidators were attached with all the high courts, and so official liquidator were selling and were distributing the proceeds, and their reporting was to the high courts. So that was the process which was actually run by the courts through the liquidator. Okay, so that is the same nature is there of the proceedings, liquidation proceedings. Now the liquidation proceeding is liquidation proceedings are actually run by the adjudicating authority through the liquidator. So we must have seen that, all the reporting is to the adjudicating authority. All reports which we file with the honorable adjudicating authority, and ultimately application for dissolution is filed there. Each and every report goes there, and then SCC is only for the purpose of making some recommendations. No actual decision-making power. They can't instruct liquidator to do the things in a particular manner, because it's a legal process where assets are disposed of in a transparent manner, and then sale proceeds are distributed. So no discretion with the COC in this process. But insolvency resolution process, as I told you, that it is a process which is a kind of out of the court settlement proceedings, which is for insolvency resolution, which was not part of the statutory process which used to be there earlier. So it was not part of that process. It's a kind of settlement proceedings, out of court settlement proceedings, where Honorable Court is having limited powers only to supervise. Rest of the powers are with the COC, because COC is the real stakeholder. So COC can decide as to what amount of resolution they should accept. Okay, so all decisions, so this process of insolvency resolution is run for and on behalf of the COC. COC appoints the resolution professional. COC decides approves the RFRP documents. COC approves all other documents like eligibility criteria, then evaluation matrix. So everything is done by the COC. And finally, plan is also approved by the COC. Only limited powers are there with honorable adjudicating authority, and that power is to see that yes, the provisions of law have been complied with while approving a resolution plan, and mandatory contents of the resolution plans are included there, are part of the resolution plan. Okay, so that is the limited role which honorable adjudicating authority is having. So that is because of the nature of proceeding. So as I said, first part of the proceeding is out of court settlement kind of proceedings, where creditors and the resolution applicant, though actually intention of resolution process was that CD will also be coming forward. Though now we have disqualified them, most of the CDs under section 29A. But originally purpose was that CD will come forward, CD will settle with the COC. So it was a kind of settlement proceedings between CD and COC. But now we have disqualified, in most of the cases we have disqualified the ex-promoters, and these proceedings are actually the proceedings for settlement between the COC and the resolution applicants. Okay, so this is the nature of proceedings. Similarly, under individual insolvency also, so same resolution process is there, insolvency resolution process is there, which is prior to bankruptcy process. So bankruptcy process again is a court-driven process, which is through the bankruptcy trustee. Court is running this process through the bankruptcy trustee. Bankruptcy trustee sells the assets and then distributes them amongst the stakeholders as per the provisions of the law. And prior to that, there is a process, and that process is for settlement, where debtor can negotiate with the creditors and stakeholders for settlement. And if that settlement takes place, then that is allowed to be implemented. Okay, so nature of proceedings in both the insolvency resolution processes is same. The creditors are having the maximum powers, and limited powers are there with the adjudicating authority for the purpose of overseeing that yes, provisions of law have been complied with. So this was then 30 subsection 4, 66% voting. With 66% voting, a resolution plan can be approved. Then effect of approval also, all of us are aware, that is provided under section 31, that if a resolution plan is approved by the COC, then it is binding. It is binding on all corporate debtor, employees, members, creditors, central government, any state government or any local authority. But here it is important is that it is binding on central government, any state government, or any local authority to whom a debt in respect to the payment of dues and arising under any law for the time being in force, such as authorities to whom statutory dues are owed. It is binding on them only. Only those statutory authorities which are creditors of the CD. So if suppose your resolution plan says that central government will exempt you from charging of income tax for a period of 10 years, so that is not binding on the central government. because there the relief which you are providing is not central government is not a creditor. You are asking them to provide them these reliefs as a central government who is having powers with respect to waiver of income tax. Okay, so central government or any state government or any local authority, if they are a creditor, then this plan will be binding on them only with respect to the treatment of their dues under the resolution plan, otherwise not. Then guarantors and other stakeholders involved in the resolution plan. The words involved, other stakeholders involved in the resolution plan, that means each and everyone other than those who are listed here, members, employees, creditors, etc. Okay, so this is this one, section 31. Now let's come to today's topic, which is due diligence before finalizing the resolution plan. As a resolution professional, we have to do a lot of work when we receive resolution plans. So as you know that we have to conduct the entire process, starting with the issuance of publication for inviting claims, verification of claims, preparation of information memorandum, and then looking after the going concern status, maintaining the going concern status of the business, then preparation of RFRP document, preparation of eligibility criteria, inviting EOIs, expression of interest, processing of expression of interest, and then inviting resolution plans. And then the process, when we receive resolution plans, after that we have to do this exercise, which is due diligence before finalizing the resolution plan. Though resolution plan is to be approved by the COC, but lot of work is required to be done by the resolution professional. So what due diligence is to be conducted by them, that is, those things are listed here in this list. And after that, those particular things have been elaborated in this presentation. One, the resolution plan. So these are the things which are required to be examined by the RP after receipt of resolution plans. Our resolution plans submitted after due date specified by the COC under regulation 36B shall not be considered. So this is 39(1)(a). So this is that particular regulation which very clearly says that if you have received any resolution plan after the due date specified by the COC, you don't have to consider that. Okay, but there may be a situation that you are having only one resolution plan, or there may be a situation where you know that the resolution applicant who has filed this resolution plan with some delay is a resourceful party and is a very serious party, and you want them to be there in this. So I think in that case, what you have to do is that you have to convene a meeting of the COC and then get the time period extended. Then only you can consider this, or with the approval of COC only you can consider that, otherwise not. Okay, so this is one, that resolution plan submitted after due date shall not be considered. Then RP must check that the RA who has submitted the resolution plan is included in the final list of eligible PRAs. So if there is a PRA who was not part of the final list of eligible PRAs, okay, so you can't consider the proposal or resolution plan submitted by said PRAs. So as you are aware that you have to, after you receive the expressions of interest, then you have to process them. And after processing them, you have to make two lists. One list is provisional list of eligible PRAs, and second list is final list of eligible PRAs. So the list, the applicant who has filed a resolution plan must be there in the final list. If he is not there, you can't consider the resolution plan of such a PRA. The person signing and submitting the resolution plan is authorized by the PRA on whose behalf the resolution plan has been submitted. So in all the cases, we have to see that the person who is signing it is authorized. PRA is authorized as per its constitutional document to participate in the resolution process and for acquisition of the CD. This thing is also very, very important, that if some company is giving a plan for the acquisition of your company, of the CD, then in that case, you must see that this PRA is authorized to acquire this kind of business. Because if the objectives of that company may not allow, then in real estate sector, we have seen that many associations are there who are submitting their resolution plan for the purpose of acquisition. So we have to see from their bylaws and the particular act which is governing this type of entities as to whether they are allowed to participate in this type of process. Okay, so then only we have to consider them for the consider their resolution plan, or we can consider them eligible only when this requirement is met. Then the resolution plan contains the information based on which the PRA was considered as eligible. So in the resolution plan also, so these are the things which should be there in the resolution plan. So normally, as you know, that expression of interest we consider, and based on the same we decide that yes, such and such parties are eligible. But ask your PRAs that they must include in the resolution plan also the basis on which they are treated as this one, as eligible. Okay, so that information must be there in the resolution plan. Then RP must ensure that all the relevant information and access to the relevant documents was provided to the PRA before submission of resolution plan by the PRA. So this is very, very important role on our part, that not only that we have to provide them all the relevant information, all the documents also we are required to be shared with them. And normally, most of us, we form that virtual data room or data room where physical record is also available. So there we give them access. They can examine each and every document, the all past data of the company, balance sheets have to be there, title deeds have to be there, litigation, all litigations, documents have to be there, orders, if any, whatever orders have been passed, all those things have to be there. Okay, so all relevant information must be there, and we have to make huge efforts to see that all relevant information is provided to the resolution applicant. Otherwise, subsequently, they may raise certain issues against you. Okay, though normally we provide in our RFRP document and information memorandum also that this is the information, and the acquirers, they have to acquire it on as is where is basis, and they have to do their due diligence, their own due diligence and all. But in spite of these this type of provisions, I think we must ensure that maximum or all the relevant information should be provided to them. All litigations, we must give the disclosure before them. All cases which are pending, we must share with them. All title deeds, etc., should be shared with them, so that they can take a proper decision with respect to the acquisition of the company. So all liabilities, all details of the liabilities, all issues, everything relating to the assets of the CD, all assets must be included in the information memorandum. So these details are required to be given so that the PRAs, they don't create any difficulty subsequently. A resolution plan contains the relevant particulars of the PRA, including its net worth, directors, nature of activities, area of operations, summary of its financial statements for last few years, etc. So other than what is already provided in the earlier clauses, the details of particulars of PRA should be given there, because our resolution plan should demonstrate that the PRA is capable of implementing the resolution plan. So for that purpose, we need its details of his net worth, who are the directors, what has been their experience, what have been the activities of these PRA, area of operation, summary of its financial statement for the last 3 years or 5 years, their balance sheet, their profitability, so that we can demonstrate that a resolution applicant is capable of infusing the necessary capital, is having the necessary expertise which is required for the resolution of this particular industry. Okay, so those details are required to be given in the resolution plan. And that there is a requirement under section 39 also, a regulation 39, that we must demonstrate that the COC has to see that the resolution applicant is capable of implementing the resolution plan. So for that purpose, this information is required to be given. His balance sheet should also be attached. All the relevant documents should be attached along with the resolution plan by this resolution applicant. Then these are very important legal provisions which have to be complied with by a resolution plan. PRA is not ineligible as per section 29A. We will elaborate it subsequent in the subsequent part. So we must see that section 29A ineligibility of the PRA is not there. Then the resolution plan complies with the requirements of RFRP document. Okay, so RFRP document has been approved by the COC. So we must see that whatever requirements are mentioned in the RFRP documents, those are complied with. Resolution plan is accompanied with the specified amount of AMD. So whatever AMD amount has been specified, has been fixed by the COC. So that amount must be there along with the resolution plan. The resolution plan complies with the provisions of section 30 subsection 2 of IBC. So this is very, very important part of the provisions. Section 30 subsection 2 of IBC must be complied with. If these provisions are not complied with, then a resolution plan can't be approved by the COC. It can't even be placed before the COC by the resolution professional. Then resolution plan contains the measures required for resolution of the CD, including the measures listed under regulation 37 of CRP regulation. So as you are aware that regulation 37 is there, which lists the measures which can be adopted by the resolution applicant for a resolution of the CD. Okay, so this regulation 37 is not a mandatory thing. Regulation 37 is only suggestive. It's not mandatory. It's only indicative. So it provides as to what can be included. It is not that each and everything has to be included in the resolution plan. All measures are required to be taken required to be taken with respect to the CD. Okay, so that is only indicative, and there can be things which are different from what is provided under regulation 37. Our resolution plan contains the mandatory contents as specified under regulation 38. Okay, so not only that we have to see 29A compliance, we have to see compliance of 30 subsection 2, we have to see the compliance of regulation 38. So regulation 38 is very, very important. It lists a number of requirements which are mandatory in nature. So each and every plan we must see as resolution professional that yes, whatever is provided in the different provisions of regulation 38, those are complied with. The information which is required under regulation 38, that is provided in a resolution plan. If not, then the resolution plan will not be treated as complying with the provisions of law. So that will have to be then rejected. PRA has submitted the undertakings affidavits as specified in regulation 39(1). So under regulation 39(1), there is some requirement that certain undertakings have to be given, affidavit has to be given by the PRA. So that is also, we must check that these undertaking and affidavits, they are part of the resolution plan. So all these things are very, very important. 39(1), 38, 30, subsection 2, section 29A. So these are the compliances which are required to be made. The COC, while considering the resolution plan, has complied with the requirements of regulation 39(3). Okay, so it is also very, very important that 39(3), regulation 39, sub-regulation 3 lists certain things which have to be done, which have to be complied with by the COC. And as a resolution professional, our duty is to bring it to the notice of COC when they are considering a resolution plan. So we must request them, we must advise them to consider all those things, the requirements which are there under regulation 39(3). Those have to be complied with by the COC at the time of considering approval of resolution plans. Okay. So above requirements are elaborated in subsequent part of the PPT where the relevant provisions have been reproduced. So let's see now what are those provisions which are required to be complied with, which are important for our due diligence of the resolution plans which we receive. So these are the steps. These are the steps which are required to be taken while doing the due diligence. All those things have to be complied with. All these steps are required to be taken by us to as part of the due diligence exercise to be conducted before before placing some resolution plan before the COC and before submitting a resolution plan before the adjudicating authority after its approval by the COC. Filing of the resolution plan before the adjudicating authority. So relevant provisions are contained in section 30, subsection 6. The RP has to submit the resolution plan approved by the COC to the adjudicating authority for its approval. So subsection 6 of section 30. So under section 30, subsection 4, a plan is approved by the COC, and 30 subsection 6, a plan is to be, the plan which is approved by COC is to be submitted before the adjudicating authority for approval. RP shall submit the resolution plan as approved by the committee of creditors to the adjudicating authority. So this is section 30 subsection 6. And then we have 39(4). 39 subsection regulation 39 and sub-regulation 4. So it provides, so it is very, very important that RP shall endeavor to submit the resolution plan approved by the committee to the adjudicating authority at least 15 days before the maximum period for completion of CIRP under section 12. So if your CIRP period is expiring in 180 days, so at least 15 days prior to the same, we should endeavor to submit our resolution plan before adjudicating authority. Though in most of the cases I have seen that only in the last 1 or 2 days, these plans are filed with the adjudicating authority. So resolution plan must be submitted. Resolution plan approved by the COC should be it should be tried that at least 15 days prior to completion of the resolution period is submitted before the adjudicating authority. Then, in addition to this resolution plan, along with the compliance certificate in Form H of Schedule 1, so we are aware that along with the resolution plan, Form H is also required to be submitted, which contains all the relevant information, which on the basis of which an honorable adjudicating authority can take a decision for approval of the resolution plan. And third thing is evidence of receipt of performance security. So these are the three things. One, the plan has to be submitted before the adjudicating authority along with the application. Then the compliance certificate in Form H, and third thing, that proof of receipt of performance security. If you have not received the performance security, then there is no plan, because performance security is important. If the RA does not give you performance security, then in that case, though you may still file it with the honorable adjudicating authority, but it will not be in compliance with section 39 subsection 4. You have to then go back to the COC that RA has not deposited this one. But if suppose time period has expired, then in that case you will be approaching honorable adjudicating authority only. Then the documents which are required to be attached along with the application for approval of resolution plan. So these are the documents which are required. Copy of the final resolution plan, copy of the minutes of the COC approving the resolution plan along with the voting results, copies of minutes of all the COC meetings, copies of relevant orders of NCLT and LAT, public announcement, Form G published by you, summary of valuation reports, determining the liquidation value, relevant emails and correspondence, copy of LOI issued to the SRA, copy of EOI of SRA reflecting its eligibility, copy of Form H, proof of deposit of performance security, all other relevant documents and required fee. So these are the documents which are required to be attached along with this one. Now, measures for insolvency resolution to be incorporated in a resolution plan. So as I told you that regulation 37 contains the measures which can be adopted in a resolution plan by the resolution applicant for the resolution of the CD. Okay, so these are not mandatory things. And these are only suggestive. Let's see. Measures for insolvency resolution. A resolution plan shall provide for the measures as may be necessary for insolvency resolution of the CD for maximization of the value of its assets, including but not limited to the following. So there can be other measures also, and out of these also there can be any measure. And these measures are transfer of all or part of the assets of the CD to one or more person. Then B is sale of all or part of the assets, whether subject to any security interest or not. Okay, so you can sell, you can transfer all or any part of the assets, okay, of the CD. So it is not necessary that under a resolution plan, the company has to continue. It is not necessary. So there can be another resolution applicant, and resolution applicant says that I want to acquire the entire business of the CD. Okay, so he gives a plan of that kind. So that plan will be based on sale or transfer of all the assets of the CD to the resolution applicant. Okay.
Sir, one question: if suppose CD having 3-4 projects, can he sold out 2 projects because transfer of all or part of the assets under this clause A? So can he do it, sir?
Yeah, your question is whether he can do it to one or more
assets of the company. Like if we are having total 9 projects and CD want to dispose of 2 projects, so I give a plan for the 2 projects only.
Okay. So now question is, though presently under law provisions are not there, but if we see this particular section, this particular regulation, and clause A and B, it allows us to do that. Okay, transfer of all or part of the assets of the CD to one or more person, or sale of all or part of the assets, whether subject to any security interest. Recently, in a matter, Honorable Chennai and bench of NCLT has approved a resolution plan with respect to two businesses or 2 assets of the CD, and rest of the assets were not viable. So they have initiated the process for liquidation of the remaining businesses. So if a company is having, if a CD is having more than one assets, and one of the asset or one business is viable and others are not, then question is whether a plan can be approved for one of the project. Answer is yes, because here also A and B also allow that to happen, and otherwise also, because it is not that if the entire business is not viable or all businesses are not viable, then the viable business should also be liquidated. So that is not the intent. Maximization of value of for the creditor will be done if viable business is transferred or sold, and the unviable businesses, they are liquidated. Okay, so according to me, it is possible, though this difficulty has been expressed to the IBVI, that there should be clear provision under the regulations for transfer of for resolution of part of the assets and liquidation of the remaining corporate debtor. Okay, so I think there should be some change in regulations or clarity in regulations. Though very clearly it is not provided, but it is possible. So as I said, that adjudicating authority, Chennai bench of NCLT has done recently. I can share the details also as to in which particular matter this has been done. Okay, so so it is possible.
So, sir, meaning thereby RP as a one in a one transaction or in a one company, he is RP and simultaneously a liquidator also.
No, liquidator he will become only when liquidation order is passed. So what he has to do is that a resolution plan for a particular asset is there, for a particular business is there. So he will be filing application for the purpose of approval of that resolution plan and liquidation of the remaining business of the city. And once that plan is approved and liquidation process with respect to remaining asset is initiated, then he becomes a liquidator.
Correct. So he can play the role of as an RP and liquidator with the subject to the approval of the court and all that.
Yes.
1%.
But if a company, there is no resolution plan, so after that RPs become liquidator, though there was some communication by IBBI to the NCLT requesting them not to appoint the RPs as the liquidator. Okay, but otherwise it was happening. So RPs can be appointed as liquidator. They can be RP also and they can be liquidator also, but after the liquidation process starts.
Right, sir.
Okay.
Thank you, sir.
Right.
Thank you.
And not only this, there can be more than one plans. Suppose there are two businesses in a company. So two separate RAs can be there and they can give resolution plans. Two RAs, they are giving separate resolution plans for the acquisition of two separate businesses. So even that is also possible. Okay. Okay. Next is BA. Restructuring of the corporate debtor by way of merger, amalgamation and demerger. So if under demerger also, it is possible that one or more assets of the company can be transferred to a new company, to a separate company. Okay, so merger is also possible, amalgamation and demerger is also possible in case of under the resolution process. So by way of a resolution plan, merger, amalgamation and demerger is also possible. Then substantial acquisition of shares of the CD or the merger or consolidation of the CD with one or more persons. Substantial acquisition of shares of the corporate debtor is part of each and every resolution plan, because in normally all the resolution plans, what we provide is that the existing share capital will extinguish and the fresh share capital will be issued to the resolution applicant. So resolution applicant acquires the corporate debtor by substantial acquisition of shares, and normally it is a fresh share capital. In most of the cases, the existing equity capital is wiped out and it extinguishes. Then cancellation or delisting of any shares of the corporate debtor if applicable. So cancellation, as I said, in most of the plans, the cancellation of equity shares of the CD, existing equity share of the CD is provided, and then only fresh issuance of shares in favor of the resolution applicant is there in the resolution plans. Delisting of any shares of the CD if applicable. So it is also, we have seen that most of the resolution plan, a number of resolution plans, they provide that after approval of resolution plan, delisting will be there of the shares of the CD. Satisfaction or modification of any security interest, which is also part of most of the resolution plan, that after payment of the dues of the secured creditors, as per the resolution plan, their charges will be treated as satisfied, and or the modification will be there of their security interest. Suppose the debt gets reduced. Suppose original debt is for example, 500 crore and restructured debt under the resolution plan is 200 crore, then modification of security interest has to be there. The liability of the lender has to reduce to 200 crore, and to that extent only they will be having security interest over the assets of the CD. Curing or waiving of any breach of the terms of any debt due from the corporate debtor. So it is also there in most of the resolution plans. So whatever breaches have taken place, now restructuring is there, new novation of contract is there through the resolution plan. Now whatever is provided in the resolution plan, that will be binding. Okay, so past breaches, they are treated as cured or waived. Then reduction in amount payable to the creditors. Also, it is also there in all the resolution plans, because all resolution plans provide that the financial creditors, operational creditor, and others, their dues will be reduced substantially based on the value of the assets of the CD. Then extension of a maturity date or a change in interest rate or other terms of a debt due from the corporate debtor. So this is also there, that extension of a maturity date, that repayment period may be extended, because almost in all the matters repayment periods have expired, or if the financial creditors they have recalled the loan, so then entire amount has become due. So now under a resolution plan, the maturity date can be extended. The maturity date can be 1 year, 2 years after the approval of a resolution plan. Change in interest rate is also in mostly all the matters are there. Normally they provide that in if mostly interest waiver is there, if restructuring over a period of time is there, so interest rate also get reduced in the resolution plans. Other terms of a debt due from the corporate debtors. So all kinds of other terms and conditions are provided in a resolution plan. Amendment of the constitutional documents of the corporate debtors. Okay. So if there is any change in the memorandum of association and articles of associations, so those documents can also be amended by way of this resolution plan. So if suppose resolution applicant proposes to initiate some new line of activity which is already not there in the constitutional, in the objects of the corporate debtor, so that can be amended here. If there are any conditions, any terms and conditions which are required to be included in the articles of association, so that can also be done through the resolution plan. So resolution plan can provide that the memorandum of association will be changed or will be altered in a particular manner. Similarly, articles of association can also be amended the way it is provided in the resolution plan. Okay. Issuance of securities of the CD for cash, property, securities, or in exchange for claims or interest or other appropriate purposes. So issuance of securities is also because fresh shares are may be issued, fresh debentures may be issued to the resolution applicant or to the investors. So that is also part of the resolution plan. Then change in portfolio of goods and or services produced or rendered by the corporate debtor. So as I have said earlier also, that in the resolution plan, it is not necessary that the same goods and services have to be provided by the resolution applicant. Resolution applicant can provide that after acquisition of the company, he will produce certain goods or services which were not being manufactured by the CD earlier. Okay, so change in portfolio of goods or services can also be made by the resolution applicant through the resolution plan. Change in technology used by the corporate debtor, so that is also possible. It is not necessary that the same machinery or technology is to be used. So the plan may provide that the new technology will be used by the resolution applicant for the purpose of manufacturing and all. Obtaining necessary approvals from the central and state government and other authorities. So this is already part of the regulations, other regulations 39 also. that necessary approvals, rather 38, not 39, necessary approvals from the central and state government and other authorities which are required for the purpose of restart of business of the CD. Okay, so that those things are listed in the resolution plan. So obtaining necessary approvals from the central, state government and other authorities, that should also be the part of the resolution plan. So these were the provisions of regulation 37. I think let's break for 10 or 15 minutes and then we can restart again. Harshita?
Yes, sir.
Let's break for 15 minutes.
Okay, sir.
Okay. Okay. Let's restart.
Yes,
Shall
sir,
we
we
restart?
can.
Yes,
Okay.
we can start.
Yes.
Okay. Okay. Mandatory contents of the resolution plan. So, as we are aware that Regulation 38 contains, other than Section 30, subsection 2, we are having mandatory contents which are prescribed under Regulation 38. So, yeah. So, mandatory contents are: 1, the amount payable under a resolution plan to the OCs shall be paid in priority over financial creditor. So, your plan must provide, each and every plan must provide that the OCs shall be paid in priority over financial creditors. So this clause must be there in each and every resolution plan. Sometimes resolution plan says that the OC's liquidation value is nil, so nothing is going to be paid to them. Okay, but I think that is not compliance with this clause. Compliance with this clause will be that they must provide that, yes, 1, that as per section 30 subsection 2, that they will be paid their liquidation value, and secondly that OC shall be paid in priority over all financial creditors. Okay, so this clause must be there. B, the amount payable under a resolution plan to the FCs who have a right to vote under subsection 2 of section 21 and did not vote in favor of the resolution plan shall be paid in priority to a priority over financial creditor who voted in favor of the plan. So that is the dissenting financial creditors. They have to be paid in priority over the assenting financial creditor. So this clause should be there in a resolution plan. Clearly, it must be provided, and the plan period, the timelines which are mentioned in a resolution plan, those should also be seen by us to see that the dissenting financial creditor, they are provided, they are paid, or they are proposed to be paid in priority over the assenting financial creditor. If assenting financial creditors are required, are proposed to be paid over a period of 1 year, then before payment of them, the payment to dissenting financial creditors should be made. So they have to
Sir,
be paid.
I have question here. What is
Yeah.
the logic behind it?
Okay, logic, I will tell you the logic behind this. Right. So logic is that the secured financial creditor, you know that in a resolution plan, the COC, first of all, COC decides as to what is to be done. So OCs are OCs are not in the decision-making process. 1 minute, please. Let me switch it off. Yes. So OCs are out of the decision-making process. So that is why the resolution plan should provide that the operational creditors, they will be paid minimum their liquidation value. Okay, so that is an exit option has been given to them. Similarly, dissenting financial creditors, so they are in the decision-making process along with the as part of the CUC. So, but if the resolution plan, they don't agree with the resolution plan, they don't want to take a risk. For example, suppose resolution applicant says that I will pay your dues over a period of 2 years, but but a particular financial creditor feels that he feels that the payment may not be made within the 2 years period. He does not want to take risk, and he feels that he wants to exit. So exit option has been given to him. He says that, okay, I am taking my liquidation value and then give me on priority basis. I don't want to wait for 2 years. Okay, so what are the rights of these creditors who are allowed to be exited? One, financial, the dissenting financial creditor who does not participate in the resolution process, he is entitled to the liquidation value and then get out. So he can't be given. He can't be paid after the assenting financial creditor, because assenting financial creditor, they have decided, they are decided that yes, they want to approve the resolution plan, they want to participate in the resolution plan. And why they are participating, why they will be participating? Because normally liquidation value is lesser, normally, though it can be higher than the resolution amount also. But normally liquidation value is lesser than the resolution applicant. Suppose RA says that, okay, all the financial creditors, I will pay over a period of 2 years, 100% of your dues. Okay, so based on the same, some of the secured creditor, they feel that yes, they will be benefited if they participate in the resolution plan. So they will be given, they are ready to give them give the RA 2 years time period. But there is one secured creditor who is having doubts and who constitutes less than 34%. Okay, so then in that case, law gives him exit option, that if he decides, he takes his liquidation value, which may be 60% of his dues. So he is saying that I am taking my 60%, I am getting out. I don't want to wait for 2 years, I am getting out. So this is the justification, or this is the logic for the same, that exit option have been given. So it is not that all of them are bound by the resolution plan terms. If some creditors, they want to exit, so they dissent to the plan, and then they are given their liquidation value, and that liquidation value can't be paid to him after the payment is made to the assenting financial creditor, because assenting financial creditor have taken that risk as per the resolution plan. So dissenting financial creditor has not taken. He says, whatever is my value, pay that value to me now, I am going out. So that is the justification for this. Okay.
Okay, got it.
Yeah. Then shall be paid in priority our financial creditor who voted in favor of the plan. So 30 subsection 2 says, section 30 subsection 2 says that the dissenting financial creditor will be given their liquidation value. Okay, and this regulation says that they will be paid in priority over the assenting financial creditors. Similarly, OCs, regarding OCs, this regulation says that they shall be paid in priority over financial creditors, and 30 subsection 2 says that, subsection 2b says that they will be, the OCs shall be paid, they will be paid their liquidation value or the value distributed, resolution amount redistributed as per section 53, whichever is higher. So that is the minimum guaranteed amount to operational creditor under section 30 subsection 2. And here it says that they will be paid in priority over all financial creditor, whether assenting or dissenting. OCs have to be paid in priority over dissenting or assenting, all financial creditor. But dissenting financial creditors, they have to be paid in priority over assenting financial creditor. Then 1A, a resolution plan shall include a statement as to how. So similarly, this clause also needs to be there. It must be provided in the resolution plan that these dissenting will be paid in priority. And then we have to see it. So it should not happen. Plan should not provide that the dissenting financial creditor will be paid over a period of 3 years and assenting are being paid over a period of 2 years. So it should not happen. It should clearly provide that yes, dissenting will be paid in priority over the assenting financial creditor. 1A, a resolution plan shall include a statement as to how it has dealt with the interest of all stakeholders, including financial creditors and operational creditors of the corporate debtor. Okay, so this is another important thing, that we must ensure that each and every resolution plan which we examine, it provides very clearly as to how the different stakeholders being treated in the resolution plan. So for this purpose, you must see the liabilities, all the liabilities of the corporate debtor, and all those liabilities must be dealt with in the resolution plan. Okay, so all secured creditors should be dealt with in the resolution plan as to how much money they will be getting, how much time period they will be getting the money, whether there is any interest which is payable. So all terms and conditions must be there with respect to the treatment of all stakeholders. Then secured financial creditor, unsecured financial creditor, operational creditors, suppliers of goods and services, workers and employees, statutory creditors. So treatment of all of them must be specifically provided so that in future there is no confusion or uncertainty. Okay, so this is a mandatory clause. Like all other clauses under Regulation 38, you must ensure that each and every liability has been dealt with in the resolution plan, and not only the liability, but also other stakeholders like preference shareholders, how they will be dealt with, equity shareholders, how they will be
One
dealt
question.
with. Yes.
If we paid to the dissenting creditor in the first, and suppose later on RA failed to make the payment of the plan during schedule of the payment, so then what is the face of the same? Well, suppose I am dissenting creditor, I got my money first in the hand and RA paid it, but later or sooner he will not able to pay to the other secured creditor as per the schedule. So can the dissenting person who has got the money, he has to revert back the money?
No, he has
So
taken
then-
he has not taken any risk. He has taken his liquidation value. He has not taken the liquidation value of others. Liquidation value of other is still there in the business. So why should he return?
So then when the company will go into liquidation, suppose plan fails, so then he will not get anything.
He will not.
If the value may be increased.
Yes.
That is the full and final payment.
Yes, full and final payment he will receive from the company. The liquidation value is the full and final amount which he gets. If company goes into liquidation subsequently, he will not get anything further.
Okay.
Okay.
Right, sir.
Okay. So money treatment of all stakeholders, equity shareholder, preference shareholders must be provided in the resolution plan as to how they will be dealt with. So it is also very important. 1B. A resolution plan shall include a statement giving details if the resolution applicant or any of its related parties has failed to implement or contributed to the failure of implementation of any other resolution plan approved by the adjudicating authority at any time in the past. So a statement has to be there by each and every resolution applicant to this effect. Okay, though this statement does not disqualify. If suppose a person, a resolution applicant takes over a company under IBC and subsequently he is not able to implement that resolution plan, it does not disqualify him. It does not disqualify him only because that he has failed to implement the resolution plan approved by the adjudicating authority. But this clause must be there. This information must be available with the creditors, so that creditors or the COC can take a decision based on his track record. Okay, so this statement should be there. 29A does not contain this thing unless and until you are aware that if suppose he has taken over some company from CIRP process, a resolution plan has been approved in his favor, and then after that the accounts become NPA of that company, I think for a period of 3 years. For a period of 3 years after he has acquired the company, that disqualification and that particular disqualification will not apply. But after 3 years, if an account has become NPA and that continues to remain so for a period of 1 year or more, then he may become disqualified in future. But only because he has failed to implement or contributed, or he has contributed to the failure of implementation of any other resolution plan, does not disentitle him or does not disqualify him to participate in a resolution plan. So this information also must be there from the resolution applicant. If it is not there, we have to ensure, we have to ask him to write very clearly that whether he has failed to implement or he has contributed to the failure of implementation of any resolution plan. 38 sub-regulation 2. A resolution plan shall provide the term of the plan and its implementation schedule. So this is also very, very important that in the form of a table, this information is to be provided in a resolution plan as to what will be the total term of the plan, total implementation of the resolution plan, how much total time period is required for the same, and the implementation schedule. And implementation schedule is normally in the form of a table where we write as to how and when different provisions of the resolution plan will be implemented, like payment of CIRP cost. So normally we take approval of resolution plan as the date X, and then sorry, and then if plan says that the CRP cost is to be paid within 30 days, so then payment of CRP cost X plus 30, payment of OCs, then X plus 60, then payment of dissenting financial creditors, X plus it may be 90, payment of assenting secured financial creditors, such and such time period, handing over of the completed flats to the home buyers in such and such period, project wise, and all those things are required to be stated in the implementation schedule. Okay, so detailed term of the plan and implementation schedule must be provided in each and every resolution plan. We must ensure that the management and control of the business of the CD during its term. So this is already there. This is there under section 30 subsection 2 also, that a resolution plan must provide as to how the resolution applicant will manage and control the business of the corporate debtor, who will be there in the management, and how the control of the business of the CD will be carried out by the resolution applicant. So these details are necessary. Each and every plan must provide as to how he is going to manage the affairs of the corporate debtor. Okay, so it is mandatory, must be provided therein. Adequate means for supervising its implementation. It is also part of section 30 subsection 2, and even 31 also provides for the same. Section 31 also provides for the same. So adequate means for supervising its implementation. So normally, as all of us are aware, that we provide that monitoring committee will be formed, and what will be the power of monitoring committee, till what point of time monitoring committee will be in existence. Okay, so all those things, who will be the members of the monitoring committee and all, how decision making will be done by them, what decisions they can take. So these provisions are required to be there. So adequate means for supervising its implementation, that yes, plan is getting implemented, so there has to be a body for supervising the same. So adequate provisions must be there in a resolution plan in respect of the supervision of implementation of the plan. D, provides for the manner in which proceedings in respect of avoidance transactions shall be pursued after approval of resolution plan, and the manner in which proceeds, if any, from such proceedings shall be distributed. So if the avoidance applications, some avoidance applications are pending before adjudicating authority, so plan must state as to how these, who will be running these proceedings, who will be pursuing these proceedings, and who will be the beneficiary of the money, if any, recovered. Okay, so if against the erstwhile promoters you have filed applications under 43, 45, 66 and all, okay, so those proceedings, the plan may say that the whatever recovery is there, that will go to, for example, the financial creditors, or it may go to corporate debtor, so that resolution applicant will be the beneficiary of the same, or it may provide that this money will be shared in a particular ratio. For example, it can be shared in the ratio of 50-50, or so this type of provision has to be there as to how the money which will be recovered as a result of avoidance application or avoidance proceedings will be dealt with in the resolution plan. How the proceeds will be utilized or distributed amongst the stakeholder, that must be provided in a resolution plan. And the suppose resolution plan says that the financial creditor or secured financial creditors will be the beneficiary. So the plan may provide then these proceedings will be pursued by the secured financial creditors, and the support, all documentary support, etc., will be provided by the resolution applicant and the CD. So that type of provision can be there. Or if the plan says that the beneficiary will be the resolution applicant or the CD, then in that case, plan may say that these proceedings will be pursued by the CD only. So this type of provisions are required to be given, are required to be provided very clearly in a resolution plan. 3. Sub-regulation 3 of regulation 38. A resolution plan shall demonstrate that it addresses the cause of default. So we must, as RP, see that the plan deals with each and every cause of default. Okay, so cause of default, what were the causes of default of the CD before entering into insolvency? Okay, so those reasons have to be either estimated by this RA, or these reasons have to be shared by the RP based on the information available with him, and RA must address them all. For example, there can be a reason for default by the CD. One reason can be lack of working capital. Another reason can be that project did not get completed. Complete capital expenditure could not be incurred. So resolution plan can provide that the resolution applicant will be infusing the money which is required for the purpose of meeting the working capital requirement. It may also provide that the whatever remaining capex is there, such and such amount is required for doing the capex, and the money will be, this much of money will be infused by the resolution applicant in the CD, and then this cause of default will be dealt with. If suppose technology has become obsolete, so then he has to make provision in the resolution plan as to how he will be using the or modernize the plant, and how much money will be required for that. Provision has to be there for the same. So this type of reasons, whatever reasons have been there, causes of default, those must be addressed in a resolution plan. So RP must ensure that each and every reason has been dealt with. Otherwise, it will, how the CD will be revived. Okay, so each and every cause of default must be addressed. It is feasible and viable. So plan must be feasible and viable. All these things must be dealt with. A resolution plan must provide as to how it is feasible and viable. So if suppose you are addressing each and every cause of default, so that means that that demonstrate that the plan will be feasible and viable if we have addressed all the causes of default. So feasibility and viability also they have to provide, RA has to provide in the plan as to the plan is feasible and viable for such and such reason. So one reason can be that suppose earlier the debt of the CD was, for example, 500 crore. And in the resolution plan, you are providing, or RA is providing, that the debt will get reduced to 200 crore. Okay, so this is one thing which will contribute to the feasibility and viability of the plan. So RA may provide that the debt on approval of resolution plan, the debt of the CD will get reduced to rupees 200 crore. So then it will become a viable level of the debt of the CD. Okay, then further infusion of share capital, further infusion of funds will be there for meeting working capital requirement. As a result, the turnover of the company shall get improved. Okay, and a number of other reasons also. All each and everything has to be mentioned as to how the CD which failed earlier, which defaulted earlier, will continue to function in future without any default. So it is feasible and viable. It is also required to be demonstrated through the resolution plan. It has provisions for its effective implementation. It has provision for its effective implementation. So as we discussed, that there has to be a proper mechanism, monitoring committee and all. Which should ensure that yes, implementation will take place. It has provisions for approvals required and the timelines for the same. So it is also very, very important that whatever business was being done by the CD. Okay, so now that business is lying closed for the last few years. Now RA has to provide as to what approvals will be required for restarting the business, and then what will be the timeline for doing that. For example, if suppose if factory license is expired, then he has to get that renewed. So factory license will be that it will provide the timeline that yes, within 30 days it will be approved. It will be obtained. Okay, then further approvals can be there, like in Haryana, for doing construction you need license from DTCP. So scheme should provide, plan should provide that the time period within which the approval from DTCP will be there. So the plan may provide that within 3 months, so he has to estimate as to how much time this process will be taking. So though law section 30 subsection 2 provides, 30 subsection 2, yeah, it provides that the timeline which are required, or for these approvals, 1 year's time period, up to 1 year's time period can be provided. Not more than 1 year's time period should be provided for all this. But we have to see that it should not happen that we are providing for each and everything 1 year time period. But and as a result, the revival or resolution is getting delayed. So, but ultimate decision is to be taken by the COC. If COC is ready to give them 1 year time period for approvals, then it's okay. Then we can't do anything as a resolution professional. So plan must provide as to what will be the approvals required for the purpose of doing construction. So this kind of license may be there. Building plan approval may be there. And this one, the clearance from pollution control authorities is required. All those things are required to be determined by the RA, and then a list has to be given, and he must estimate as to what will be the time frame, what will be the timeline for the same. So all the approvals required and timeline for the same, it must be provided in the resolution plan. Resolution applicant has the capability to implement the resolution plan. So I told you earlier that your resolution plan must provide the particulars and details about resolution applicant, his net worth, his past performance, his business and all. So this will help you in demonstrating that yes, resolution applicant has the capability to implement the resolution plan. To show that yes, he has the capability, you have to show that yes, he has the resources which are required. His net worth is good. He is having good amount of funds available in the company. Then you have to see that yes, he has the management capacity also, that he has been running some business profitably over a period of time. Then you have to show that the particular business which was being done by the CD and which is proposed to be continued by the resolution applicant. So RA is having the necessary experience in this particular field, or otherwise he is engaging the services of those who have the understanding of that particular business. So resolution applicant has the capability to implement the resolution plan. It is very, very important, and management management competence should be there, resourcefulness should be there, and the experience or knowledge of a particular industry has to be there. So the resolution applicant should have the capability. It has to be demonstrated by your resolution plan. If it is not, then the adjudicating authority may not approve it, or the COC may not approve it. Then Regulation 39. So these were the provisions which were mandatory in nature. Regulation 38. These are the mandatory contents. We must ensure that each and every clause of this particular Regulation 38 is complied with. Otherwise, our plan will not be treated as in compliance with the provisions of law, and it may be rejected by adjudicating authority. Regulation 39 of CRP regulations. Approval of resolution plan. So 39(1), a prospective resolution applicant in the final list may submit a resolution plan or plans prepared in accordance with the code and these regulations to the RP electronically within the time given in the request for resolution plan under Regulation 36B, along with the affidavit. So we will come to affidavit later. But before that, a PRA which is there in the final list. So it is important that PRA must be there in the final list. If he is not there, you can't include him there. He may submit a resolution plan electronically. This is also very important. In many cases, we take the resolution plan physically, but that will be contrary to this one. So you may take additionally, you may take physical copy of the plan, but it must come electronically to you. Okay, so plan, and you are aware that financial creditors are also supposed to submit their claims electronically only. Okay, so similarly here, plan must be, you must receive that electronically. In addition, you may get physical copy, but electronically it must be submitted. It should come to you through a mail. Though electronically is also interpreted to mean that if through a pen drive it is given. But I think it should be through mail, so that at least the evidence is there, yes, that within the time this plan has come, then within the time given in the RFRP document. So that means if a resolution plan has been received subsequent to this particular timeline given, then you don't have to consider that. Okay, so but normally we don't want that somebody should be excluded for the said reason that he did not give the plan. So we take the approval of the COC for the same. Okay, so because the RFRP document is approved by them only, so we can make the necessary changes with the approval of this one, of the COC, and we take that into this one. Then what are the documents with the affidavit, which is affidavit as per 39(1) is affidavit stating that it is eligible under section 29A to submit resolution plan. So it is also mandatory that whenever you are receiving a resolution plan, though we also have to do the due diligence to see that section 29A disqualification is not there to the resolution applicant, but an affidavit is also required. So each and every plan must be accompanied by an affidavit stating that the resolution applicant and all the people who are connected, they are eligible under section 29A to submit resolution plan. Then C, an undertaking by the prospective resolution applicant that every information and record provided in connection with or in the resolution plan is true and correct. So this undertaking is also required to be given. Normally we take this undertaking at the time when UIs are submitted, but that is a separate requirement, and here this requirement is separate, that there must be an undertaking from the resolution applicant that whatever information is there in the resolution plan is true and correct, and if subsequently it is found that the information which was submitted was wrong or false, okay, then the resolution applicant may be treated ineligible to continue in the CRP process. His refundable deposit can be forfeited, and he becomes liable for penal action under the code. Okay, so this undertaking is also very, very important, that yes, whatever information is there in the plan that is true and correct. So this is very, very important thing. So one, section 29A affidavit. Secondly, undertaking by the PRA that yes, information provided is correct. So this was section regulation 1, sub-regulation 1 or regulation 39. Then the regulation sub-regulation 1A, 39(1)A. RP may, if envisages in the RFRP, allow modification of the resolution plan received under sub-regulation 1, but not more than once. Use a challenge mechanism to enable resolution applicants to improve their plans. Okay, so these are not relating to this one, due diligence part, but at the same time, we have to comply with these provisions also. And challenge mechanism, I think that is the best thing to use. Otherwise, if we are asking them to give their resolution plans, and then on those resolution plans, we ask them to improve, and then after that, we get that voting done. I think better will be that we use a challenge mechanism. And challenge mechanism can be open bidding, or it can be a Swiss challenge method. So I think open bidding is much better. Otherwise, in Swiss challenge also, people, they raise issues, they raise objections. If it is open bidding, in that case, then chances of challenging the same are less. Though Swiss challenge method also, this open bidding is used. In Swiss challenge also bidding is used, and based on the same, the highest bidder is selected, who is to be matched by the base bidder. Okay, but still I think better will be if we use open bidding mechanism, where chances are very less that issues will be raised against you. Okay, then receive shall not the 1B, committee shall not consider any resolution plan received after the time as specified by the committee under regulation 36B. Okay, so again, I think earlier also this provision was there, that resolution plan has to be submitted in time. Again, this sub-regulation provides that COC shall not consider any resolution plan which is received after the time as specified by the committee under in RFRP document. B, will not consider, committee shall not consider a plan which is received from a person whose name is not there in the final list of PRAs. Then C, the COC shall not consider any plan that does not comply with the provisions of subsection 2 of section 30. Okay, so it is not only the responsibility of the RP, but of the COC also. That COC also has to see that if there is a violation of subsection 2 of section 30 and subregulation 1, then in that case, the plan is not to be approved by the COC. So these are the provisions where committee has to, COC has to comply with these provisions, and though the same obligations are there on the RP also, but this particular sub-regulation says that COC is also liable, or COC is also has to see that it is that the requirements of 1B are complied with. Then sub-regulation 2, RP shall submit to the committee all resolution plans which comply with the requirements of the code and regulations made thereunder, along with the details of following transactions, if any, observed, found, or determined. So compliant resolution plan has to be submitted by RP before the COC. But in many cases, what we see is that whenever we receive resolution plans, so deficiencies are there, compliance is not there with different provisions of law and regulations. So what we do is that we inform all of them that these are the deficiencies which you need to clarify. Okay, or you need to amend your resolution plan. So they need to correct the plan, and after making those compliances, then they submit, and then we place that before the COC after that. And still, if some resolution plan is not compliant, then in that case, we are not supposed to submit. But I think what we have to do is that we have to place it before the COC, inform COC that this plan is non-compliant and cannot be considered by the COC. Okay, then so these are the whenever you are you are placing the resolution plan with the committee, then you have to give the details of these transactions, avoidance transactions also. So 43, 45, 50, and 60. And if any order has been passed. So it is also important that whenever you are holding a meeting of the COC for the purpose of considering the resolution plans, then in that COC meeting, in your notice, along with the notice, these details must be shared with the COC as to what are the transactions for which you have filed these applications, and whether any order has been passed by the adjudicating authority in respect of these applications. committees shall evaluate the resolution plans received under sub-regulation 2 as per evaluation metrics, record its deliberations. So whenever you are holding a meeting of the committee, whenever you are holding a meeting of the COC for the purpose of considering the resolution plans, kindly ensure that these things are done. The committee must evaluate the resolution plan received under sub-regulation 2 as per evaluation matrix. Though now evaluation matrix relevance is lost, the evaluation matrix is not that relevant, because earlier the significance of having an evaluation matrix was that based on the evaluation matrix, we used to identify the resolution plan which get the highest score, and we were getting the voting done only on that resolution plan which gets the highest score. But now provisions, regulations are changed. All the resolution plans have to be voted upon. So this the importance or the significance of evaluation matrix is not there for the purpose of identifying a plan which is having the highest score. However, now its usefulness is only to assist the COC as to which plan should be accepted, and COC is not bound by this score. This is for the guidance of COC, but COC may still decide that they are accepting a resolution plan which is having lower score than the other. So, but they should in the minutes they should record the reason for the same. Though they are free, ultimately they have to vote on if 5 resolution plans are put for voting. So that means the COC is free to vote on each and on any of these resolution plans. Okay, so even though it is not required that they should vote only on the resolution plan which is having the highest score as per evaluation matrix. Okay, so they are free to vote on any of the resolution plans, whether the score is less or more. Okay, but we must see that evaluation matrix, as per the evaluation matrix, there is a scoring which is made by the normally RPs. They do that evaluation and they place it before the COC, and then COC discusses that, and then COC may on its own wisdom give the score. Normally 2 types of scores are there. So subjective and objective. Okay, so objective thing is that, or what we call so subjective thing is where you are where you have the discretion. You have the discretion to give a particular score. But
we call it QC-based systems, or quality-based and
qualitative and quantitative. You are right. So quantitative are where you don't have any discretion. So how much money has been offered, how much time period that has been offered. So quantitative criteria based on the same scoring is to be done. Then qualitative criteria is also there, where the discretion is with the COC. Okay, so discretion, but they have to be guided as to what they have written. Okay, so in the evaluation matrix, so based on the same, they have to discuss. This discussion should be recorded in the minutes, so that the compliance of this particular clause of regulations is there. Then record its deliberations to the feasibility and viability of each resolution plan. Nowadays, adjudicating authority, they ask the RPs to show as to whether the COC has considered feasibility and viability of each resolution plan. So it must be recorded in the resolution, in the minutes of the meeting. Each and every plan should be separately considered, and COC should determine whether a particular, you should record it there, that whether a particular plan is feasible and viable. If it is feasible, why it is feasible, why it is viable. All those things are required to be mentioned. If it is not feasible, then what is the reason that you are treating it as non-feasible and non-viable? So this deliberation is must be recorded in the minutes. Otherwise, your plan may not be approved by the adjudicating authority. C, vote on all such resolution plans simultaneously. So earlier we were required to vote on only one resolution plan, but now all the resolution plans have to be voted upon. 3A, where only one resolution is plan is put to vote, it shall be considered approved. Now, it is not that only one resolution plan is there. More than one resolution plans are there. So now you have to see as to how the best is to be selected. Okay, so if only one resolution plan is put to vote, then it should be considered approved. If it receives 66% or more of the votes, then only it will be treated as approved. If it is getting less than that, then it is treated as if it is not approved. Where two or more resolution plans are put to vote simultaneously, the resolution plan which receives the highest votes but not less than requisite votes shall be considered as approved. So minimum 66%. If suppose more than one plans, they get more than 66%. Suppose one plan gets 70%, another gets 68%. So the 70% that will be treated as approved. Okay, where two or more resolution plan receive equal votes, but not less than the requisite votes. So now if suppose two resolution plans are there and they receive equal votes, suppose both of them they get 50%, then 50% each. Then, but not less than the requisite votes, the committee shall approve any one of them as per the tiebreaker formula announced before voting. I think here there is an error. I feel there is an error. 1 minute, let me check.
Sir, may I ask one question?
Yes.
Sir, all these regulations and our provisions of IBC clearly stated how to draft a resolution plan, and there are provisions and regulations to be while drafting a resolution plan, we have to keep in mind all those things. But still, sir, practically, being an RP, we find out the problem that people are sending their plans, the RA, without following all these guidelines and without following the provisions, although it is the duty of the RP to make them complied with and then inform them. Why not some changes to be made there that RA should follow these, or some kind of draft should be there of the plans, so that because 70-page plan, 80-page plan in a matter, you got a 5 plans, then it's a difficult task for the RP to conclude the matter within 180 days.
Okay. No, actually it is for the RA to give a compliant plan. If it is not compliant, you can reject that. But because you want a competition to be created amongst them, you want maximum number of resolution applicant participating in a process. Okay, so if some non-compliance is there, then you will be informing them, and it is your duty. Even if suppose all the plans are compliant, but still you have to go through and see that all of them are totally compliant. So even if they give a compliant plan, your duties still remain to see. Okay, so now coming back to this, provided that where two or more resolution plan receive equal vote, but not less than requisite vote. If both the resolution plan receive more than 66%, then they have to be approved as per the tiebreaker formula. So minimum here requirement is that they should receive not less than 66%. If they receive less than 66%, then again voting will be there on the plan which is having a higher number of votes. But if there is a tie, if tie is there, if they receive equal votes, but more than 60%, more than this one, 60%, more than 66%, then the COC will approve that as per tiebreaker formula announced before voting. So important thing is that you have to announce one tiebreaker formula. Normally, I think better will be that you include that in the RFRP document. Okay, otherwise you may miss having some tiebreaker formula. This tiebreaker formula has to be approved by the COC, and this tiebreaker formula can be based on different things, like for example, if it is a case of real estate, then if a plan has got 60, both the plans have got 70% of the votes, then 70% is calculated based on the voting by the entire class. So the total class votes of the total class go go in favor or against based on how majority have voted. Okay, so your tiebreaker formula can be that in place of rather you may say that for the purpose of tie breaker thing, you will consider the actual number of votes voted in favor rather than on the vote considering the votes of the entire class. So that can be one thing. Then another basis can be the, you can say that NPV of the values which have been offered, and a number of other things, and time period. So that is totally for the COC to decide as to what should be the tiebreaker formula. RP can propose certain things, and then finally COC has to approve that. So this is this one where two or more plans receive equal votes but not less than 66%. And this can be better understood through this table. If a voting outcome, plan A receives 55, plan B receives 60. So in this case, both. So this is this one, provided further that where none of the resolution plan receive requisite votes, committee shall again vote on the plan that received the highest vote subject to the timelines under the code. So if 55 and 60, if there are two plans, one plan A and another is plan B, plan A receives 55, plan B receives 60. So both of them, they have received less than 66%. So none of them is approved. But then in that case, we have to get the voting done again on plan B only, not plan A. So plan B, if it gets 66%, then it will be treated as approved. But again, if it gets less than 66%, then it will not be treated as approved, and then company may go into liquidation. Second situation where plan A 70, plan B 75, both the plans have got minimum 66%. So in that case, because now 75% is the higher number, so plan B will be treated as approved. Third situation where both the plans, they have got more than 66%. But both of them, there is a tie. Both of them have got 75% of the votes. Then in that case, tiebreaker formula, which has to be announced prior to voting, that will be applied, and based on the same, the successful plan will be treated, will be selected. Then I think these things we can skip. These are the other provisions relating to submission of resolution plan before the adjudicating authority and all. Let's go to mandatory contents as per section 30 of IBC. I think very quickly, let's go through the same. 30.
Sir, can you ask a question here?
Yes.
So you had mentioned that dissenting financial creditors will get the liquidation value.
Correct.
In prior to the secured ones.
Correct.
In home buyers case, let's say there are 30% who are dissenting. Their vote will be counted as 100% only depending on the majority.
Correct.
So will they be, how do we treat them?
Yeah.
Do we treat them as dissenting,
Yes,
non-dissenting?
Yes. So Mr. Rana, actually in case of a creditors in a class, so you are aware that they are bound by the majority view. Okay, though in the COC, we are having 100%, suppose 100% votes, out of that 70% are in favor and 30% are against. So 30% will be treated as dissenting creditors. But in a class of creditors, whatever decision is made by majority, okay, for example, there is a class of home buyers, and that home buyers, they are having 60% of the voting share in a COC, and rest 40% are financial institutions and banks. So 60% of the home buyers, if their voting will be done on the resolution plan, and suppose out of 60%, only 40% come for voting, remaining 20% they don't vote. Out of 40%, 21% are in favor and 19 are against. So then, because majority who has voted, okay, so they are in favor of the plan. So plan will be treated as approved by this. So those who have actually voted, if they are majority, their 66% thing is not there. So in a class voting, the decision is to be made based on majority vote of those who have actually voted, and that decision will be binding on all. That means the entire 60% votes will be treated as voted in favor of the resolution plan. So in a class, there is no dissenting financial creditor. In a class, all of them are treated as assenting financial creditor, not dissenting financial creditor. Okay.
And this should be valid for all classes.
For all the classes, yes.
Correct.
So if different classes are there, then the entire vote of that class will be decided on majority, how majority has voted. Okay, so
either they are all dissenting or they are all assenting. It's
so
one way or the
either,
other.
yes, you are right.
Okay.
So if all of them they vote against, if all of them they vote against, so then they will not be treated as voted in favor of the resolution plan. All of them will be treated as dissenting financial creditor.
Got it.
Yeah. Coming back, 30. Submission of resolution plan. So this one, a resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under section 29A. So this is very, very important that there should be this affidavit which must be submitted by the resolution applicant. Then RP shall examine each resolution plan received by him to confirm that each resolution plan A provides for payment of CIRP cost in priority to the payment of any other debt of the CD. Okay, so plan must provide that CIRP cost will be paid in priority to all other debt, whether financial, whether operational. So CIRP cost in payment priority to every other cost. OCs will be paid an amount which shall not be less than these two things are there. Amount to be paid. So one is their liquidation value. So operational creditors are also guaranteed their liquidation value because they are not part of the decision-making process. So there is one guarantee to them that if they want, in any case, they must be given that much of money. Whether they want or not, their will is of no consequence here because laws gives them protection. Law says that they must be given this much of money in the plan, and that value is the one liquidation value which is payable to them under section 53. Or if suppose, for example, in a company, the liquidation value is, for example, 100 crore. Okay. Liquidation value is 100 crore, and based on the same, secured creditor in that company, their dues are 120 crore. Okay, so in case of liquidation, these OCs will not get anything because entire money will go to secured creditors. Okay, so in that case, their liquidation value will be nil. Okay, so liquidation value nil, but the resolution applicant who is coming, he is offering 150 crore rupees. Okay, based on the business valuation. Business valuation can be more. Liquidation value is 100. Business valuation is 150, for example. And if he is offering 150, then in that case, the operational creditors must get the value which is to be calculated, this 150 crore to be distributed as per section 53(1), and whatever share comes to them, so that is also guaranteed. So out of 150, 120 will go to the secured financial creditor, 30 remains. 30 will go to whom? To the operational creditor. Okay, so in this manner we have to do the calculation. the amount which is offered in the resolution plan by the total amount which is offered by the resolution applicant in the plan, that is to be redistributed as per section 53, and whatever amount becomes payable to the operational creditor, that must be provided in the resolution plan. Okay, so higher of these two, liquidation value as per section liquidation value as calculated as per section 53, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with section 53, whichever is higher. Then provides for the payment of dissenting financial creditor. Dissenting financial creditor must be paid their liquidation value. So value which is to be calculated as per section 53(1). So dissenting financial creditors are also guaranteed the liquidation value. They have been given the the exit option. Explanation 1. It is hereby clarified that a distribution in accordance with the provisions of this clause shall be fair and equitable to such creditor. Okay, so in this particular clause, whatever amount is being offered, that should be fair and equitable to the creditors. So it should not happen that you are offering something which is not fair to that particular creditor. C. Provides for the management of affairs of the CD after approval of the resolution plan as to how management will be run, who will be there in the management and all. Implementation and supervision of the resolution plan, we have already discussed, does not contravene any of the provisions of the law for the time being in force. So this is very, very important for us. We have to determine, we have to certify as resolution professional that the plan does not contravene provisions of the law for the time being in force. So if your resolution plan says that the company will be entitled to carry forward the business losses for a period of 10 years, so that is in violation of provisions of Income Tax Act. So you cannot permit this type of clause in the plan, or unless he can say that Income Tax Department can consider granting this relief. So that is another thing. That is not mandatory for IT department to give to this one. So total discretion will be with the Income Tax Department. Okay, so there should not be anything. While you go through the resolution plan, you must see that there is nothing which is in contravention of the provisions of law for the time being in force. Conforms to such other requirements as may be specified by the board. So whatever is provided in the regulations, that is to be seen. Then I think we can skip these things. Then 4 is also important. The committee of creditor may approve a resolution plan by a vote of not less than 66% of voting share of the financial creditor after considering its feasibility and viability. So we discussed there in regulations also that we must record that feasibility and viability is considered by the COC. The manner of distribution proposed, which may take into account the order of priority amongst creditor, is laid down in section 53, including the priority and value of the security of a secured creditor and such other requirement as may be specified by the board. Here important is that manner of distribution proposed. So CLC has to consider that. It is fair and reasonable, and it take into account the order of priority amongst creditor as laid down in subsection 1 of section 53. So it should not happen that you are giving money to someone who is not entitled under section 53(1), some amount which actually other one is entitled. Okay, so you can't say that unsecured financial creditor we will not give anything, but operational creditor we will be giving some money. So like that, it should not be like that. It should be fair and reasonable, and COC has to ensure that, not the RP. Then approval of resolution plan, we are aware. I think we can skip this one. And ineligibility, section 29A. Very quickly, let's go through this. Section 29A, I think here we are required to make a lot of efforts. We have to see that the RA is not ineligible under section 29A. Okay, so for that purpose, due diligence has to be done. Normally, we take the help of outside consultants also, other applicants, other insolvency professionals or lawyers for the purpose of doing this thing. And because a lot of work is required, you have to consider the eligibility of all those who are part of the resolution, applicant, management, and the promoters and all. A person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. So not only that, we have to see that the resolution applicant, but if he is acting jointly or in concert with any other person, so then the eligibility of that person also is to be seen. Okay. So these are the disqualification, that he should not be, any of these parties should not be an undischarged insolvent. Okay, so undischarged insolvent, you are aware, though this type of term is not there used under IBC, undischarged insolvent, except here under section 29A. So undischarged insolvent is actually undischarged bankrupt is a term, but undischarged insolvent is not. Okay, so I think we assume that if a person is under insolvency, okay, or bankruptcy, then he will be treated as undischarged insolvent. So RP has to see that a RA is not someone who's with respect to whom these proceedings are going on, insolvency or process, or this one bankruptcy process is going on. B is a willful defaulter in accordance with the RBI guidelines, so he should not be a willful defaulter. Then C is that there should not be any account which has become NPA for more than 1 year. It has to be counted from the date of ICD, insolvency commencement date. So there should not be any account of the RA or any company under his management or control.
So for these purposes, we have to, how much we have to rely on affidavit presented by RA regarding all this?
No, affidavit is one thing, but at the same time, I think we must make our efforts. We have to make efforts, and a lot of information is not available. But still, like RBI defaulter, willful defaulter list, we may not be having the access. But still, we have to do some due diligence. We have to read through their balance sheets if there are any notes about the same. We have to go through the different websites maybe there. We can ask them to give their this credit score and all that. So some bit of this one is required. Due diligence is required. So it is not that only on the basis of affidavit we can certify or we can say that they are eligible or they are not ineligible under section 29A. Okay, so for each and every clause, I think we must make some efforts. Then, so account turning NPA for more than 1 year, that is another disqualification. Then we have further is he has been convicted for any offense punishable with imprisonment for 2 years under the act specified under 12th schedule, or for 7 years or more under any law for the time being in force. Okay, so he should not be convicted of any of the offenses under as per this clause. Then if this clause shall not apply to a person after the expiry of a period of 2 years from the date of his release from the imprisonment. Then is disqualified to act as a director under the Companies Act. So if RA or of any of the person acting in concert with him is disqualified to act as a director under the Companies Act, then also he is disqualified. He is prohibited by SEBI from trading or accessing the securities market. Okay, so this information can be available on the SEBI website. Has been a promoter or in the management of a CD in which a avoidance transaction has taken place and in respect of which an order has been made by adjudicating authority. So this is another disqualification, clause G. H is that if a guarantor, if the RA has given a guarantee in respect of a creditor and has executed a guarantee in favor of a creditor in respect of a corporate debtor, in favor of a creditor in respect of a CD, against that corporate debtor, if application has been admitted, application for CRP has been admitted, and the guarantee has been invoked by the creditors and remains unpaid in full. Okay, so this clause says that the guarantor, the creditor who has invoked the guarantee, he should initiate CRP against the corporate debtor. Okay, and the guarantee should have been invoked and some amount should remain outstanding. Only then. But Honorable Supreme Court has clarified this issue. Honorable Supreme Court says that the guarantee can be by any of the creditor. That application for initiation of CRP can be by any of the creditor. It is not necessary that the same person who is holding the guarantee, he only has to initiate the CIRP. So it is not necessary, though this clause says so, is subject to any disability corresponding to clauses A to H under any law in a jurisdiction outside India. So if outside India he is disqualified in the clauses which are similar to these outside India, then also he will be disqualified. Has a connected person not eligible under clauses A to I. Okay, so here important is one, that if any of these persons, they fall within any of the above mentioned clauses. Any person who is the promoter or in the management or control of the resolution applicant. So that means if A Limited is resolution applicant, so then its promoter or management or the person who are controlling its shareholding, they should not be disqualified. So RA's promoter or those who are there in management or control, they should not be disqualified. Any person who shall be the promoter or management or control of the business of the CD during implementation of resolution plan. So after implementation of the approval of resolution plan, so the person who will be there in the management or control or the promoter, he should also not be disqualified. Third is the holding company, subsidiary company, associate company or related party of a person referred to in clauses A to 1. So here, holding company, subsidiary company or associate company or related party. A related party means each and every relative. Okay, so for example, if suppose there is a big business, there is a big industrialist who is qualified, but his relative, his brother is disqualified. His brother has committed defaults to different bankers, and he is disqualified. Then will this industrialist will also be disqualified under this particular clause, a related party? Any answer?
Technically, yes.
Okay. No, but Honorable Supreme Court has interpreted this clause. Honorable
In Reliance case, it was not accepted.
Yes. And the justification which was given by Honorable Supreme Court was, if you see the language here, holding company, subsidiary company, associate company, or related party. So Honorable Supreme Court said the holding, subsidiary, associate company, the words which have been used here, all those words are those who are having business connection with the CD or the RA. So related party, only that related party who is having business connections or who are acting jointly or in concert, only those. So if your brother is not having any business connection with you or is not participating in this acquisition along with you, then you will not be disqualified only because your brother is a defaulter. So on that basis, so the language, the interpretation of these words has been, the related party here means the related party who is having business connection, the similar kind of connection which holding, subsidiary, associate companies are having. Okay, so this is relating to this one. I think 29A, we must check that yes, 29A compliance is there. I think some judgments are there. I think we are not left with any time now. It's already 5. We can close this session here only. Any questions?
Sir, whether operational creditor can demand for a resolution plan which is already approved,
They can, sorry, they can.
whether they can ask for copy of resolution plan which is
Huh.
already approved by AA.
Actually, yes, definitely they can. Otherwise, how will they know as to what treatment they will be given? They have been given in the resolution plan.
So
They
whether
will be entitled.
whether RP is allowed to share or he has to approach to AA.
No, the RP can also provide. RP should provide if they are asking the RP, then he should provide that. Or if resolution plan has been approved and implemented. Okay, so in that case, the if it is implemented, then they will not be needing it. So after approval of resolution plan, you are there as the chairman of the monitoring committee.
Sir, it should be provided, no? Because otherwise, how will they know whether
How
they
will
have
they
been
know?
given
And then
dissenting amount or not?
Definitely, Mr. Rana. And at the same time, it is the duty of the RP to inform each and every creditor as to what is his entitlement in the resolution plan. Okay, so I think there also you are required to, I think, share with them the resolution plan.
Nilesh, one question to you.
Hmm.
To what extent the RP is liable if something comes out in 29A declaration later on, some default comes out subsequently, then to what extent the RP will be held liable for the same?
Actually, Mr. Sigdar, as you know that RP and COC, both of them are liable, both of them are responsible to see that, yes, but at the same time, suppose this type of situation comes that there is somebody who is not eligible under section 29A and still his resolution plan has been considered. I think both of them, they have to show that yes, they have made their best effort, and in spite of the same, so there was in spite of the same, they were not able to discover this particular thing. So then I don't think there will be any further action on the same. But yes, that particular resolution plan may not be approved by the adjudicating authority in that case, or if it comes to COC, the COC will not approve it.
Okay, thank you.
There was one judgment of Honorable Supreme Court wherein the resolution plan was approved. Resolution plan was approved. That was, I think, MBL infrastructure matter. So resolution applicant was a defaulter. Resolution applicant, the same, actually CD only submitted the resolution plan. The promoter of the CD, the account was NPA for more than 1 year. Okay, so at that point of time, only these provisions 29A was inserted. I think at that point of time, resolution plan was approved by the COC. Okay, so then I think NCLT did not approve it, NCLET did not approve it, and then finally Supreme Court approved it. Supreme Court said that yes, he is ineligible, but at the same time COC has approved it. So as an exception, they said that okay, we are proceeding with the same. However, the Honorable Supreme Court said that no, he is ineligible.
Okay. Okay, thank you.
Right. Any other question? No. So then we close this session. Harshita, are you there?
Yes, sir.
Okay. So let's close today's session.
Okay, sir.
Yes. So thank you very much, everyone. And
thank you, sir.
So much, sir, on behalf of all the participants for taking such a knowledgeable session and sparing your valuable time with us.
Okay, thank you.
Thank you.
Thank you, everyone.
Yeah, thank you. And sir, please share the PPT also, sir. It will be helpful, sir.
I will share that.
Thank you, Nilesh, sir.
Thank you, Brigesh.
Yes, sir.
Thank you, Brigesh.
Yeah. Yeah, thank you, sir.
Okay.
Thank you, Nilesh, sir.
Right, Ji. Thank you.